The litigation is about laws that have to do with imposing medical treatment on people without their consent in the context of mental health litigation. So it was a challenge to some laws in British Columbia that under certain circumstances could impose involuntary treatment. And on its face, you can imagine the concerns with that because of the requirement for consent of any kind of medical treatment. And so initially the challenge was brought by the organization, the Council for Canadians with Disabilities, and two individuals. As the process
These would have been
along,
individuals who were impacted by that mental health law about involuntary treatment.
Exactly. And those individuals would arguably have had direct standing. So kind of the discussion about public interest standing really would not have been front and center. At some point in the process of litigation, those individuals, for reasons that are not, within my knowledge, had to withdraw from participating in the litigation, had to not be part of the claim. And so the council amended its pleadings to pursue the litigation on its own on the basis of public interest standing. And that's really when the dispute started, with the province challenging the entitlement of this organization to bring the claim.
Now, Mark, is there anything you'd like to add about the background of that case, and why can it be so hard sometimes to find individual applicants who want to participate in litigation like this?
Yeah, well, I think the difficulty finding interested parties can really run the gamut. I mean, in a case like this, one can speculate as to why those two specific individuals left out. And more broadly, if you're facing mental health litigation, who knows what impacts may be had on individuals facing specific crises. More broadly, being a plaintiff in litigation isn't easy. And litigation of this nature isn't for financial payoff. It's to hold the government to account. And there's no big payday at the end of a long, arduous process for the plaintiff involved. So for somebody who has a busy life, they have a job, they have a family, they want time to work out, they read books, to then add in, okay, well, you're going to have the responsibility of making all these litigation decisions, committing to it for what could be 4 or 5 years, maybe longer. You'll be asked all kinds of questions. You'll be exposed to all kinds of scrutiny in public, in the media possibly. It's a lot to ask in the current environment.
Yeah, I know we've brought some litigation as a public interest organization alongside individuals through my work at the Canadian Constitution Foundation. And it takes a lot of courage for people to stand up and say, I'm willing to be named as an applicant or as a plaintiff or as a petitioner, because it attracts attention and it can attract a lot of negative attention. Now, Eileen, I apologize. What's your view of why the government might be trying to make the test for public interest narrower, public interest standing narrower? It seems somewhat self-serving to me, since it, after all, is the government getting sued, and it would obviously be in their best interest to make it harder for them to be sued.
Well, I think that's certainly part of it. The way that we talked about it in court last week was that we think that it's really the government expressing its preference for how this kind of litigation should be addressed. And there's strategic benefits for a government in facing litigation brought by an individual rather than an organization that has the connections and resources and the capacity to have the staying power, as Mark's kind of adverted to pursue complex litigation over a period of years. So there is a strategic aspect to it. On the other hand, a government might have, legitimate resource allocation issues that it's worried about, and it thinks, I think based on stereotype, but it believes that there's going to be too much litigation brought if organizations are allowed to kind of bring these things willy-nilly. But that's not been the experience in real life.